In this episode, we will be discussing California tenant abandonment laws and breaking a lease. California Civil Code Chapter 2, Section 1951.2 sets forth the following penalties if a tenant abandons a rental property or breaks a lease. Penalty for breaking a lease. If a tenant breaches the lease and abandons the property before the end of the term, or if his or her right to possession is terminated by the landlord because of a breach of the lease terminates. Upon such termination, the landlord may recover the following from the tenant: the unpaid rent which had been earned at the time of termination, the amount by which the unpaid rent which would have been earned after termination exceeds the amount of such rental loss that the tenant proves could have been reasonably avoided, the amount by which the unpaid rent for the balance of the term exceeds the amount of such rental loss that the tenant proves could be reasonably avoided. This is to be computed by discounting the amount at the time of award at the discount rate of the Federal Reserve Bank of San Francisco plus 1%. And any other amount necessary to compensate the landlord for all the detriment proximately caused by the tenant's failure to perform his or her obligations under the lease, or which in the ordinary course of things would be likely to result therefrom. Interest may be charged. The amounts referred to in the tenant penalty for breaking a lease are computed by allowing interest at such lawful rates as may be specified in the lease, or, if no such rate is specified in the lease, at the legal rate. Additional damages after termination. The landlord may recover additional damages after the termination date only if the lease provides that the damages include the amount by which the unpaid rent for the balance of the term, or for any shorter period of time specified in the lease, exceeds the amount of such rental loss for the same period that the tenant proves could be reasonably avoided, or the landlord relet the property prior to the time of award and proves that in reletting the property he acted reasonably and in a good faith effort to mitigate the damages. But the recovery of damages under this paragraph is subject to any limitations specified in the lease. It is important to note efforts by the landlord to mitigate the damages caused by the tenant's breach of the lease do not waive the landlord's right to recover damages under this section. For additional laws and articles, visit AmericanLandlord.com.